Good morning, everyone. This is Asim Rahman, Chair of Environmental Control Board. I'd like to call today's April 20th, 2023 ECB meeting to order. I'd like to first ask David Kim of our GC unit to do a roll call to verify quorum.
Morning all. We'll start with Commissioner Asim Rahman,
Present.
Shamanda Graham.
Present.
Thank you. Joseph Gregory. Joseph Gregory.
Is here.
Yeah, thank you. Elizabeth Nauer. Madeline Ligori.
Present.
Gloria Martinez. Rosel Pickens.
Here.
Thank you. Matthew Schneid.
I'm
Here.
sorry, I don't mean to
Present.
interrupt. The health person is not Jorge anymore, is it?
Right. Amindapal Rana.
Present.
Okay, thank you, Rana. Thank you. Thomas Spebner.
Present.
Thank you. Matthew Smith.
Present.
Douglas Swan. Harold Whittington. Present. Thank you. Okay, we have a quorum 10 out of 12.
Thank you, David. Okay, we will move forward with a review and adoption of the minutes of our past meetings. We'll start with the February 2nd, 2023 meeting minutes. Does anyone have any corrections to the minutes you've received? Okay, would anyone like to make a motion to adopt the minutes? I see a motion from Matt Smith, a second from Madeline. And David, would you call a vote?
Okay. Are there any objections to the motion approving the minutes of the February 2nd, 2023 ECB meeting? Seeing none, hearing none, the motion is approved unanimously.
Thank you. I'd like to ask for a motion to adopt the minutes of the February 7th meeting. I'm sorry. With respect to the minutes of the February 7th meeting, does anyone have any changes? Hearing none, I'll request a motion to adopt the February 7th meeting minutes. I see Madeline. Is there a second? Thank you, Matt Smith. David?
Okay. Are there any objections to the motion approving the minutes of the February 7th, 2023 ECB meeting? Hearing none, seeing none, the motion is approved unanimously.
Thank you. I'll now turn it over to Russ Bikunis from DEP to introduce requests for cease and desist orders. Russell?
Yes, good morning, everyone. Thank you. DEP has three requests for the board's consideration at this meeting. The first one that I'll do is the one under the air code. This is for 753 Classen Avenue in Brooklyn and names the building owner, 753 Classen Avenue Housing Corp. This is a building that has a large boiler. The permit under the air code for that boiler expired in May of 2021 and has still not been renewed. The building owner was cited for having an expired permit for the boiler in October of 2022, and they were found in violation in January. A second summons for having an expired permit was issued in January, and they were found in violation at the end of February. The permit, as of now, has still not been renewed. Also, there have been numerous complaints through 311 regarding black smoky emissions from the stack at this building. We have only been able to get there when it was smoking on one occasion, which was back in 2021, which the respondent defaulted on, but did pay the fine. We had also been alerted by the New York State Department of Environmental Conservation that they had received complaints regarding smoke from this building, and that they had observed it, but again, we have not been able to catch it smoking except for the one time in 21. Based on the fact that the building has a expired permit for nearly 2 years, has been cited twice for that, and has been found in violation twice, and has still not renewed the permit. And given the prior violation for smoke and odors, smoke actually, and the complaint being forwarded to us through the state, DEP believed that it was appropriate at this point to ask the board for a cease and desist order to compel the building to obtain a valid permit for the boiler, which they will not be able to do without an inspection that certifies that the smoke problem has also been resolved. So based on that, DEP is asking the board to issue an order to cease and desist.
Russ, thanks. Does anyone have any questions for Russ? Okay. Why don't we do these individually? I'm sorry, I see a question from Elizabeth Nauer, and David, if you can kindly mark Elizabeth as present, that'd be great. Yes,
I
Elizabeth.
apologize for joining late. I had some technical difficulties logging in. I guess I'm just wondering, I presume this is a residential building, is that correct, Russ?
I believe it is an apartment building, yes.
So if a cease and desist order were issued, then I guess the course of action for required for the building ownership would be to get a temporary sort of mobile boiler to provide hot water. There would be some ability for them to maintain service of hot water if they because I'm presuming it will take them some time to either renew their permit or get a new boiler that can be permitted.
Yeah,
so
well, I mean, that would be part of the cease and desist process. Once they showed up for the cease and desist hearing, they would have to explain to the hearing officer why the boiler should not be sealed. And normally in cease and desists for something like this, that would be for them to show the judge what they were doing in order to get the permit renewed. Since this is a certificate of operation, it does require the retention of an engineer. So presumably the first thing that they would show would be that they had retained a PE to get the certificate of operation, And assuming that they showed that to the judge at the cease and desist hearing, they would be permitted to continue operating the boiler until they get it into compliance.
All right,
The
so
only
what
the
happens-
ceiling would be if they didn't show up and they defaulted on the cease and desist order, then theoretically we could go seal the boiler. Hopefully it wouldn't come to that. They have been responsive to the summonses. The two recent ones, they did show up on them. So hopefully they would also show up for the cease and desist hearing. And even if they did default on it, we would send someone to the building at that point to basically do a warning sort of thing. So I think it's highly unlikely that it would come to actually sealing the boiler, one would hope.
But have you had cases where because of just total intransigence, which I mean, this appears to be a case where they've been, while showing up in some cases, have been intransigent towards correcting the violation. So where you had to actually seal a boiler where there are affected residential occupants?
I think that would be a call that would have to be made at the time. I think the time of year might play into it because hopefully now we're coming out of the heating season, and this would not be something where the residents would lose heat. They would, if the boiler would sealed, lose hot water. The building might have to bring in a temporary boiler in that situation, a mobile boiler, to maintain the hot water in the building, which obviously they would have to do at their expense.
And then they just, based on their obligations as a landlord, they would have to do that to avoid, HPD issues, correct?
Having other issues, yes, I think so.
Thanks, Elizabeth. Any other questions?
I think we just think at this case, at this point, issuing another summons doesn't seem to be, the way to go. The summonses don't seem to have gotten their attention. So we're hoping that a cease and desist order with the language that it contains will.
Thank you. And Russ, again, this is the Classen Avenue, correct?
I'm sorry?
Are we talking about, this is the Classen Avenue?
It is 753 Classen Avenue.
Right, okay. So I'd like to move for a motion to, I'm sorry, Olga, were you going to say something? Okay, sorry. I'd like to move for a motion to approve the cease and desist order request with respect to 753 Classen Avenue Housing Corp. I see a motion from Tom, a second from Madeline. David?
Yep. Are there any objections to approving the cease and desist orders? Seeing none, hearing none, the motion is approved unanimously.
Thank you. Russ, would you like to move to the next one?
Thank you. Yes, we'll move on to the next one. So the next one is under the sewer code. The respondent on this one is 180 Brooklyn Livingston LLC. The business in question here is a Dallas BBQ restaurant, and it is at 180 Livingston Street in Brooklyn. Back in 2019, DEP performed an inspection at this location, based on which a commissioner's order was issued requiring the respondent to install grease interceptors within 30 days on several items of equipment, 3 two-compartment sinks, 2 chicken roasters, a scraper sink, a dishwasher, and each of 9 floor drains. When by October, respondent had not complied with the commissioner's order, DEP issued a summons under 24-524F of the administrative code for failing to comply with the commissioner's order. That was the first of a series of summonses that were issued for failing to comply with this order. In 2019, then in January 2020, then there was a long hiatus in enforcement of the grease trap requirements due to COVID, both because of the issues that were confronting the restaurant industry due to COVID, and because the staff that normally enforces the grease trap requirements had been largely reassigned to enforcing COVID regulations. So the summonses, there were no summonses between January of 2020 and August of 2021. And then there was another summons in March of 2022. So it appeared that respondent had begun work to comply, but there was an issue related to the inspection port being required to determine whether the interceptors were properly connected. So a new commissioner's order was issued requiring the installation of such an inspection port, and also a separate order requiring respondent to make sure that none of the interceptors had been connected in series, meaning that they were not connected through each other, but were each connected separately. So in June of last year, the respondent, having not yet fully complied with the original order that was issued in 2019, installed the inspection, had not installed the inspection report or ensured that the interceptors were not installed in series. So now a summons was issued for failing to comply with all 3 of the orders. And further summonses were then issued in July of last year and January of this year. So at that point, the respondent, having failed to appear on the most recent summonses and with still no full compliance under the original order and no compliance under the second and third orders, based on all of this extensive history, the department is requesting at this point that the board issue an order to the respondent to cease and desist.
Russ, just for clarification, the 2 most recent summonses from July 22 and January of 23 have not yet had their scheduled hearings at oath?
I'm looking for the printout on those. You're referring to the 7/19/22 and 1/25/23
Yes.
summonses?
Yes.
Okay, so the 7/19/22 summons appears to have been admitted and paid in full without an appearance having been made. And the one that was issued in January the one that was issued in January is had a hearing date a week ago today,
Okay.
and is still showing on Ticket Finder as a new issuance. So I don't know whether that means that they didn't appear or whether Ticket Finder just hasn't been updated yet.
I see. And the last on-site from DEP, meaning the last time that DEP was able to confirm that no corrective action has been taken was last June?
Let me just see if I can confirm that.
Understanding, of course, that if we proceed with cease and desist, they'd have an opportunity at that hearing to show that
Yeah.
the conditions have been corrected. I'm just curious to know when was the last time that was done?
Yeah, I would have to email the attorney for this for wastewater treatment to find out when the last time they were actually there. Was. From the paperwork, the last time that does appear to have been the last time we were there was last year, but in order to confirm that, I would have to contact them in wastewater treatment.
Thanks. I'm not asking you to contact them. Does anyone have any other questions or comments? Okay, I'll ask for a motion to approve the request for a cease and desist order concerning 180 Brooklyn Livingston LLC. I see a motion from Joseph. I see a second from Elizabeth. David?
Are there any objections to approving the cease and desist order? Seeing none, hearing none, the motion is approved unanimously.
Thank you,
Okay,
Russ.
thank you. The third one pertains to 1715 St. John's Place in Brooklyn. The respondent is We Stay Fresh Corp., and the business is the Stay Fresh Deli and Grill. For this one, DEP did an inspection in October of 21, which resulted in a commissioner's order being issued requiring the respondent to install a grease interceptor on the 3-compartment sink within 60 days. When there had been no compliance by March of 22, DEP issued a summons for failing to comply with the commissioner's order. Further summonses were then issued in March, July, September, and November of 2022. On the most recent one, which is the one that was issued on November 29th of last year, the respondent defaulted, and I believe, according to the information provided by the Bureau of Wastewater Treatment, that they defaulted on the other ones as well. They were then also sent a letter requiring them to appear for a mandatory compliance meeting on January 18th, which was to have been done over the phone, and they did not respond to that either. So since the respondent has still not complied with the commissioner's order and has also been non-responsive to the series of summonses and the certified letter requiring them to call in for the compliance meeting, at this point, DEP is asking the board to issue an order to cease and desist.
Thank you. Any questions for Russ? Okay, I'd like to ask for a motion to approve DEP's request for an order to cease and desist with respect to respondent We Stay Fresh Corp. I see a motion from Jared Whittington and a second from Tom. David?
Are there any objections to approving the cease and desist order? Seeing none, hearing none, the motion is approved unanimously.
Very good. Russ, thank you for taking us through these in detail and providing the information to the questions. We appreciate it.
Thank you all very much.
Sure. Before we move to the next agenda item, let me pause to do something that I should have done at the outset of the meeting, and that is to note that with respect to one of our participant agencies, DOHMH, we have a new representative, and you can see him smiling. It's our Harminder Pal Rana. Welcome, Harminder Pal. We look forward to working with you in this meeting and future meetings. You are not required to introduce yourself, but if you want to say a few words, the floor is yours.
Thank you, Your Honor. I appreciate it. Thank you all. I look forward to this. It's already been quite informative. My first exposure to the board's activities was, I think, several weeks ago, where I was involved in a panel to review, I think, over 100 appeals decisions, which was highly informative. I'm used to reviewing and have reviewed, obviously, Department of Health summonses and related matters, but this was actually very informative in terms of getting exposure to the range of other agencies who appear before this board. So thank you, Your Honor. I appreciate it.
We appreciate that you jumped right in and are taking it seriously. So welcome aboard.
Thank you, sir.
Okay, let's move on to item number 6 on the agenda. General Counsel Olga Stats will be presenting on a proposed revision of the summons form for particular matters. Olga?
Good morning, everybody. Happy to see everyone. I'm presuming that all of you have received the form that we're proposing for a new summons. And so before we get into a more substantive discussion, I'd like to know if anyone has just any technical questions on it. Yeah, Madeline.
Is this only going to be used for civilian petitioner?
Yes.
Or, so this language won't appear, we wouldn't have to put this on our Novus system?
Yeah, absolutely. This summons that we're presenting for your consideration is only designed for citizen petitioners. So everything you see here would not be applicable to any agency at this point. Your universal summons will remain your universal summons.
Shamanda?
Good morning, everyone. Olga, I just want to confirm that as it relates to the citizen, even issuing summons is returnable to oath. Is this limited to DEP in cases where DEP declines to write a summons where the citizen has submitted a complaint? Because my reading of that section was basically that if the citizen submits a complaint to DEP and DEP does not write a summons, they can actually write the summons themselves and make it returnable to oath. I just want to confirm that that is correct.
You are absolutely correct. These summonses apply in limited circumstances where the law specifically where and how the law specifically allows them to do it. This is not an expansion on anything that's permitted in the administrative code. This is just what we're doing in order to differentiate between the two types of petitioners and to make clear that there are different obligations on both ends.
And-
Okay, so I'm sorry, I have a few questions.
No, not at all.
So can you also confirm that this is limited to DEP? Because I did a search of the ad code and I really didn't see anywhere else or any other agency where a citizen actually has this authority. But I'm sure you guys know a lot better than me, so I figured why keep searching? Just ask the question.
No, that's a very good question, and your instinct is correct. So far, it is only limited to DEP, and I say so far because it seems that City Council is interested in expanding the citizen petitioner stuff. But so far, it's limited to DEP, both for idling violations and noise violations.
Yes, I saw that. Okay, so my next question, and this is actually more related to, I guess, the citizen themselves, because I mean, I get where the council is going and I know it's part of the ad code, but I do have a little bit of concern about the citizens' contact information being on this form, because basically the city has granted the citizen the authority to sort of serve as an officer and an agent. And I guess the respondent would have the right to sort of compel the citizen's appearance, right? I guess that's what I'm worried about. I know that you guys can adjudicate without the petitioner necessarily being present, but is there any plan on how that would be handled when the respondent sort of demands the petitioner? I don't know. I feel a bit concerned about that.
Well, several things. The requiring the appearance of a witness is something that we've been doing since time immemorial. Let's go back to taxi cases. For example, if someone is challenging a taxi driver for having done something to them, that person must appear. And so that already is the precedent for that. Then and that's just for the witness. Now, here we're talking about the petitioner, him or herself. This citizen complainant is acting as an agency in the agency's stead. And the same sorts of obligations that an agency would have, the petitioner has in terms of setting out allegations and proving those allegations. And so this is not identifying the complainant so far has not been problematic for us because a lot of the citizen petitioners put in their email addresses. So that's just an obligation. That's just part of being a petitioner. Someone has to know who you are and someone has to be able to contact you. So far, it's been email addresses. Sometimes it's phone numbers, but that's at the choice of the citizen petitioner.
Okay, that makes absolute sense. And then the last question is that I also understand that the big message on the form that says this is not a sworn affidavit, is that basically addressing that it's not an automatic prima facie case the way with the city agencies because the issuing officer is, they have a different capacity than a citizen.
That is absolutely correct. The charter gives the board authority to determine the forms and the content of summonses. And the charter specifically says that when a summons, whatever its form, is sworn to, that summons becomes prima facie evidence. Now, we all understand that the charter, when it was passed in the admin code, et cetera, the object was to have city agencies with city employees issuing these summonses. And as we all know, city agencies and city employees are subject to a lot of anti-fraud, anti-crime obligations. They receive special training, not only in the substantive matter, but also in due process related matters and adjudicatory related matters. So when the city made this we're surmising that when the city made this possible as a prima facie case, the city was taking all of this into account, that they weren't pitting people who did not have boundaries around them against respondents. So in this instance, in order to make sure that a citizen complainant who's basically putting himself in the stead, this is basically more like a private right of action than it is the city going against someone. Although the city gets a portion of the proceeds, this is more a private right of action. So we wanted to make sure that the citizen petitioner was in the place of a regular plaintiff or a regular petitioner who is obligated to, number one, appear, and also obligated to prove every aspect of the complaint or the petition that he or she puts forward. So basically, we're just putting these citizen petitioners in the same place where they should be in the scale of things in adjudications.
And I said that was the last one, but I'm sorry, I just have one more. Does DEP have any authority or ability? I guess what I'm thinking about is if the citizen submits a complaint to DEP, and maybe Russ should answer this, and DEP declines to prosecute, but yet the citizen maybe insists, or the citizen decides to write this summons, does DEP have any authority or any, basically DEP's out of the equation? I guess I'm trying to reconcile the situation where DEP has intentionally declined prosecution and a citizen member writes a summons anyway.
Well, that's a very, Russ can fill in.
Yeah, sure. So when a complaint comes in from a citizen, DEP has three options. DEP can issue a summons based on that complaint, which we write and prosecute. DEP can declare that that complaint is frivolous or duplicitous, which in effect kills that complaint. And not only will DEP obviously not issue a summons in that case, but the complainant also cannot issue a summons. Or DEP can take no action within the time period specified in the statute, which is 45 days in the air code and 30 days in the noise code. If DEP does that, option 3, takes no action, then the citizen acquires the right to issue their own summons.
So in other words, they do not have the right unless you guys take absolutely no action. And your result of their complaint submission is communicated to the citizen, and that they do not have those rights. I guess I'm thinking about how would the citizen know that they don't have the right, and I think that needs to be.
Believe me, they know. They are because they have to get the summons forms through us. The moment those deadlines expire, they are requesting blank summons forms so that they can issue their own summonses. They want to, most of them, or many of them, want to issue their own summonses because they get more reward money if they issue it themselves. So they are keeping track of when the 45 or 30-day periods expire.
Got it. So you have your frequent flyers who have basically suited and booted up. They're our idling police. I gotcha. And they are making lots of money from it. Okay.
Right. Well, and this is, again, while there are those frequent flyers, we're looking at this from a totality that, this should be, whether it's the frequent flyers or whether it's someone doing it for the first time, what's a right approach from a adjudicative perspective. Let me turn it over to Elizabeth, and then I see a hand from Tom. If anyone else has a question, just raise your hand. I'll keep a stack. Elizabeth?
Thanks, Commissioner. I had sort of a couple of questions about the form itself from the perspective of maybe a non-frequent flyer potentially filling it out, and how some of the boxes, to me as somebody who isn't familiar with filling them out as an agency, were maybe a little confusing and could lead this to sort of someone filling it out maybe incorrectly in a way that may confuse the respondent, leading to dismissal on notice bases or that sort of thing. And maybe you can just assuage those concerns by how the procedure works. But I guess
Elizabeth, I think maybe I could answer that at least partly. Okay. They have to get the forms to issue their own summonses through DEP. They have to come to our building in Queens to pick them up, and they are provided with an instruction form and a guide on how to complete the summons when
Okay.
they pick up the blank forms.
Okay, so I mean, can I just bring up the couple of things that I saw, and maybe those are handled in the guide, which wasn't, part of this package. One of them is, that where it says details of violation, there's a box for the oath code. How would the citizen petitioner know what the oath code is? Is that something that's like, is there a table?
Yeah,
or something
they're given the oath code
Okay.
for idling and or the relevant noise section
Okay.
when they pick up the summons.
And then there's these underneath, I guess, one suggestion that I would have but maybe it's obvious in the guide, is where there's those 3 lines, which I presume are intended for them to like put in the substantive description of what they saw or heard. That could be specified with like description of violation or description of occurrence. But maybe again, that might be in the guide. Then there's these boxes below, which would say property removed, 1 to 2 family. I'm just wondering if there should be one for like NA, because so many of these are idling cases where there's no property, premises involved specifically. It's just on the street. So that.
Yeah, the
Let's
instructions
pause there.
that we
Yeah, go
give
ahead.
them, the instructions that we give them tell them to leave inapplicable boxes alone.
Okay.
It's a step-by-step guide as to which boxes they should and should not be
Okay.
checking or filling in.
And then the one other thing that I wonder, well, 2 other things, sorry. Report level, fill 4 spaces, command, squad, unit, etc. I wondered why that was relevant to a citizen petitioner summons. Or is that
I'm
just
sorry.
something that's-
Oh, I see. You're in the bottom quadrant under the
Oh,
word affirmed.
Yes, exactly.
Okay.
Those are boxes that the citizen doesn't have to fill in. It's complicated for us to restructure the summons entirely. So we leave, so basically what you have before you is a typical universal summons with certain things changed for the citizen petitioner. We haven't changed it wholesale. So a lot of in the instructions, DEP tells them what is not necessary, and we're able to maintain the general form without getting too complicated. It's important for other ordering protocols, et cetera, for printing, that we not mess around with this too much.
Oh, okay. I just that is a good logistical explanation. I guess one option, I don't know if this would help, would be to just like blacken it out and leave the spaces formatting the same, but
Or
And so-
alternatively, Russ, can you clarify if the instructions that are given make mention of that report level field, and if they should just skip that field?
Yeah, they're told to leave it blank.
Okay. Thank you. And a follow-up question that I have is, earlier in the conversation when Shamanda was asking about contact information, it was noted by one of my oath colleagues that sometimes email addresses are just put in lieu of an actual physical address. Is that also something noted in the instructions?
We, as we are not a party to this summons, we leave that up to them to put what they choose to put in terms of how they should be contacted.
Okay.
Obviously, oath needs to contact them because they have to appear at the hearing, so oath has to have a way of getting in touch with them. Also, the respondent has the right to make a discovery request for these summonses, and they can't make that request to us because we don't have the evidence, because we're not issuing the summons. So there has to be a way for the respondent to contact the petitioner to request discovery. What I have noted, I believe, I'm pretty sure that the people that are doing this And with regard to the earlier conversation about frequent flyers and non-frequent flyers, as far as I know, pretty much the only people that are issuing their own summonses are frequent flyers, people who are heavily involved in citizen complaining. And I think some of them have actually set up P.O. boxes, and they put a P.O. box on the form so that they're not giving the respondent their home or other actual address. They're giving a P.O. box. I've seen that from several of them.
Thank you, Russ. Elizabeth?
Just my, and I guess that I'm taking it, Russ, from what you're saying, that the guide explains that it's the petitioner's choice of what contact information to provide, but they have to provide one means of contact.
Yes, they are told that they have to provide a means of being contacted by oath, and we then leave them to specify what address, whether it's physical, P.O. box, email, whatever they want to put. I don't know if the clerk's office has any preference as to what they put, but I don't believe our instructions specify what type of address has to be put there.
I will note that there doesn't seem to be a line for email address, so that might be something to consider.
It just says citizen petitioner contact information. I mean, the citizen petitioner can figure out what contact information.
Oh, I see. There's
he or
a
she
line.
wants to put in
Okay,
there.
Okay. And then the one other question I had was the tax towards the bottom, tax registry number, what that referred to.
Maria, are you on?
I am.
Maybe go ahead, Maria.
Actually, just to answer the previous question, we need the mailing address so that we can serve them with a decision. But I assure you, they contact us regularly via email, and that's how we get their email addresses. We have a registry of their email addresses as well. As for a tax registry, again, this is the universal summons. So we couldn't rearrange the entire summons just for this very small population. So what we did was we took what we had and then just made certain modifications that were tailored specifically for the citizen. We just didn't blank out everything that's there because, like Olga said, I have a printer, and the printer charges for, if we decide to reformat anything. So it's really just, we want to keep the universal summons the same for everyone in the city of New York, so that's recognizable. But in this particular situation, we did modify it somewhat to accommodate with a citizen petitioner.
If I may clarify, Russ, if you know, does your instruction guide for citizen petitioners say, with respect to tax registry number, you can leave that blank?
Yes, they are told to leave that one blank.
Okay. All right, Elizabeth, anything else?
No, thanks very much for answering my questions.
Sure. Tom? You're good. Okay, I next have Joseph, and if anyone else has a question, please raise your hand.
Yes, hi, morning. Just a question or a concern. The alternate service, does that, do you feel that poses any problem as far as it being consistent with charter service? And the possibility of maybe the citizen petitioner, I'm not saying they would, but utilizing like sewer service or not being, handling that properly?
Alternative service is what's allowed under the I mean, this is basically charter service, the ability to mail the summons in. And what happens is we also, if someone defaults, that person also receives a notice, and they can answer that notice. If one of their objections is that they never received it, that's the time in which they're able to make that statement. Maria, did you want to add something?
I did. I know where you're going, Joseph, but these are not auto-docketed. So we do not have to comply with the charter service, or they, because these are not automatic judgments. These actually go to the law department for collection. So they're allowed to do mail service. They're allowed to do CPLR service. It doesn't really matter.
Okay. Any other questions? Okay, I have a question, and it's for Olga, Peter, and Maria. Joseph has had me looking at the back where we have the affidavit of service. And if the whole point here is to have an affidavit that's unsworn for the reasons that Olga talked about, something that might confuse a user on the back is it says under affidavit of service, the undersigned being duly sworn deposes and says. Now, I think we understand that that swearing is limited to the swearing for the purposes of service and not for the purposes of the kind of allegations.
Yes.
So I wonder, should there be an amendment that says, for example, the undersigned being duly sworn for the limited purposes of service deposes and says?
That's going to depend again on what's going to happen with the printer. I'm presuming that if it's not going to be too much of a problem with the printer, we can perhaps add something like that. But I also would hesitate to mess around with a notarization for an affidavit of service.
Yeah, and so I open up here. Like, do we think that is going to create confusion, or am I making something out of?
It hasn't created. I mean, it hasn't created confusion in the past. I'm not exactly sure it would create confusion here. Also, it's given the fact also that it's on the other side of the paper, right?
Yeah.
So you have your first signature where it says you cannot swear to this, and you have just one line for your signature on the front, and then you have to swear that you've served. You have to notarize. I mean, I suppose someone could get confused, but it would probably be in a rather extreme situation in which a person would not know what's going on in that instance.
And then in terms of it being legally defensible, the fact it's on both, well, we haven't had the issue yet because everything's been sworn to so far. And this is the first time that we're having not sworn on one side and sworn on the other. And if it's challenged, are we comfortable with this, or do we think any additional clarification language is needed?
I don't see. I'm sorry, go ahead, Peter.
I don't think, and Maria can correct me, that there'd be a printer issue on adding that language that the commissioner recommended on the second page. It's just, it's not a new field. It's just some additional words to the statement at the top.
I agree, but wouldn't it be easier just to put that in the instructions that the EP sends out as clarification instead of changing the affidavit, just making it clear in DEP's instructions?
And I would have more of a litigation concern if I'm messing, because this is a standard notarization jurat portion. And it probably has a legal meaning that we're not even thinking about right now.
Sure.
So I would not be comfortable messing around with this right now.
And I like Maria's suggestion, if and we'll come to Russ in a minute, if it's possible to have the instructions clarify that if you're submitting a affidavit summons on your own after DEP has decided not to pursue, that it's not sworn to, which is separate from swearing to the affidavit of service. I just would like to just add a comment that underscores what Olga said before about what the big picture here is. I mean, the big picture here is that in courts of law, in administrative courts, if the baseline is fairness, the entity making an allegation should have a fair opportunity to present its case, and the entity that is on the receiving end should have a fair opportunity to confront and see who it is that's making the case against them. That's the baseline. And then there are exceptions to that rule. And we have an exception in New York City that allows for the prima facie case. And why do we allow that exception? It's for the reasons that Olga said. All of those particular controls are in place, that including a person's own professional obligations. Their job is on the line if they do something wrong or if they do something improper. And because those same protections are not in place when we talk about a citizen complainant, then we should revert to the default. And the default is you need to present your case. And so that this is a part of the reason behind this idea of having the non-sworn to affidavit, non-sworn to summons that doesn't get the same prima facie presumption. Shamanda?
One quick comment, and I'm not sure if it fits where it fits here, but I just want to throw it out there. Our agency had at one point looked at the notarization of the affidavit of service, and what we were trying to determine is whether or not we should be notarizing when the inspector serves the summons. And what we determined was that we would notarize whenever the person serving the summons was not an inspector. And the other thing we determined was that the summons is an affidavit, the back of the summons, the affidavit of service, is an affidavit when it is sworn to or notarized, and when it is not, it's a certificate of service.
Thank
And
you.
then it would be up to the hearing officer to make a determination as to the amount of weight they would give it, because there are differences between an affidavit versus a certificate. So I'm not sure if the language is there on the back. I could grab it, but as long as the back says certificate / affidavit, which the universal summons I do believe says, I think it's good to go.
Well,
We're taking out the word certificate here. For the citizen complainant, we're taking out the word certificate so that they can only do it by affidavit.
Got it. Makes sense to
So
me.
we're taking out, so that's one of the things that we did do. We removed that word to make it clear that you must have this notarized as a citizen petition. You have to swear to this.
Russ, did you want to chime in with anything?
Yeah, we will, just to say that assuming this form is approved and when it gets printed and when we're in a position to start giving them out, that the instructions will be amended accordingly.
Great, thank you. Any other comments or questions? Okay, I would like to ask for a motion in support of adoption of this summons, which is intended only for use by citizen petitioners authorized under the administrative code to serve and file summonses. Do we have a motion? See a motion from Matt Smith, a second from Matthew Schneid. David?
Yep. Are there any objections to approving the motion to adopt the new form of summons? Seeing none, hearing none, the motion is approved unanimously.
Okay, thank you, everyone. Appreciate the thoughtful discussion. Item 7 on the agenda, or any other additional questions or matters not discussed today? Okay, let's discuss our options for the next board meeting. David, could you please walk us through that?
Yeah. Possible dates for the June board meeting are June 1st, 2023 or June 8th, 2023.
Does anyone have any objections to either of those dates?
June 8th, I would not be able to attend.
I will not be able to attend June 1st.
I may not be able to attend June 8th, but I'm not positive.
I actually don't think I could do either of those.
Let's see.
I see. We're Tom? Tom, you're muted.
Excuse me. Can I offer a suggestion that we maybe send out meeting planners for both days? People reply, RSVP, we go asynchronously, and then, if we don't get critical mass, we reopen the question.
I think that's fine. We're heading into the summer months. People have schedules that are less predictable. Perhaps we can do this in an offline matter, if that's okay with the GC unit. Matt, did you want to add something? Matt Smith? Oh, I'm sorry. I saw a hand. Is that from a process standpoint, GC unit, is that okay for us to manage the date selection outside of the formal meeting? David or Olga? Olga, we can hear you.
I think it's fine. I think that Tom's suggestion is going to work. We'll just note it down as we all agree that we'll meet sometime in June, and steps will be taken to select a precise date.
Great. And we'll, of course, as always, make sure that that date is published.
Tom has something to say.
Yes, Tom.
Yeah, I had one other, Philip. I only just started mine, but the conflict of interest board filing is due on the 21st for those of you who have to execute those. So they're a little bit of work, and I just started mine this morning, and it's due on the 21st. So, you know.
Thanks for the reminder.
Thank you very much for that.
First
Just as
tax
Tom, this was a
day,
good
first
reminder.
tax day and disclosure day, right?
Yeah.
One
Yeah,
after another, same week.
Well, this is one that's a little lengthy, so delaying it isn't a great idea.
Okay. All right, any other comments or concerns? Can I have a motion to adjourn the meeting? I see a motion from Madeline. I see a second from Joseph. Accordingly, we are adjourned. Thank you very much, everyone. I hope you have a good day, and we will reconvene in June. Stay tuned for information on that. Thank you.
Have a great day, guys. Bye.
Bye.